And the next presenter is Gianclaudio Malgieri. With an academic perspective, he is at EDHEC Business School at the Augmented Law Institute in Lille, also at the Brussels Privacy Hub, associate professor of law and technology, and he teaches pretty much everything which our project is about: data protection law, AI regulation, digital law, data sustainability, IP, and other things. If I'm correctly informed, but correct that if I'm wrong, you will move to Leiden on the 1st of October. So you will change your affiliation, but not your focus on work of your work. And Gianclaudio is discussing just algorithms, justification beyond explanation of automated decisions under the GDPR. Please, Gianclaudio, you have the floor.
Thank you very much. Yes, you were correctly informed. I mean, my Twitter page was a bit viral. I'm so happy to be here, to see many of you face, and I know some of you, and I'm very happy. So, I mean, actually, I had questions, but we will discuss it later. Because there is this kind of bulimia of European, I'm sorry, I'm abusing of my position here, but there is this kind of, overaction of the European Commission proposing. And for scholars, it's so hard to be at pace. I mean, you finish studying one proposal, and after 2 weeks, you have to start a new one. When I saw the health data space, I said, no, please, not also this one. So I just decided to select things and go to the basics. So the presentation of today mostly will be about how the AI Act and the GDPR might interact in something. And so it's also mostly about the AI Act, and there is a part in GDPR. If we go to the next slide, are you familiar with the AI Act a bit? You are ready? So I will give for granted these slides, just a few words just to remember you how the Commission decided to approach the risks in the AI Act. So basically, we have four levels of risks. First of all, we should understand what is AI, and I'm not the good person to define it. Yesterday, we had this conference in Brussels, and the introductory statement was this quotation by Dan Ariely, changed a bit, and they said, AI for lawyers is like sex for teenagers. We all speak about it, but we don't know how to do it. So basically, we don't know so much about AI. I mean, I speak as a lawyer that I've been working with computer scientists, but it's a continuous challenge. So basically, under a broad definition of artificial intelligence that the AI Act takes, and again, the AI Act doesn't refer to AI, but AI systems, which is something more specific, there are just four levels of risks, right? And I think the real added value of the AI Act is to define a red line and say, this is not acceptable. And the orange group defines the unacceptable risks. So these practices, these systems are considered unacceptable, and this is a political decision. And I think this is the one of the real added value of the AI Act, to say we take a political decision about what is not acceptable, because it was not. I mean, you might say there is the GDPR, and in the GDPR you have already the concept of fairness, lawfulness. We will address this, but based on the accountability of data controllers, it was still a bit, fluid, these definitions. Here, you know that those things there are forbidden. So first of all, manipulation leading to psychological, of course, it's I simplified. It's like dark patterns, subliminal practices, etc., leading to harms, physical and psychological harms. Then decontextualize or unjustifiably detrimental social scoring, or indiscriminate facial recognition by police. This was the original proposal. Then we had, in April, the co-rapporteurs' amendments report, so 1 year after the Commission proposal. And then we have now the European Council, the Council taking many different steps, because we had the Slovenian presidency, who was analyzing the first part of the AI Act, the French presidency, who was analyzing the the second part of the AI Act. And now we are moving, I think, the Czech presidency, and we will have, I think, Spanish one. So we will see what will be the country that will put the flag on the AI Act. So, you know, there is an unacceptable risk forbidden. Then for the high risk, you have some design duties. And these design duties include human oversight, which is very interesting. And you might wonder, if you're curious, we can discuss it in the Q&A, but what is the difference between human oversight and human in the loop in Article 22 of the GDPR? The difference, in my view, is the moment where we put the human. Because here it's upstream, it's at the top of the process when the algorithm is being trained, while in the GDPR, the right to human intervention is at the end of the loop, just before or after a decision has been taken. And then you have data management plan and risk assessment duties for high-risk practices. High-risk practices is based on a list in Annex 3 of the proposal, and this list has been disputed a lot. At the moment in the list, you have credit scoring, workers assessment, so performance assessment, AI used in critical infrastructures. Imagine airplanes, they are based on, you know, complex information systems, we can say, used by judges, by public administrations, and so on, or all products under safety regulation. So, for example, smart toys, smart fridges, and things like that. And in this case, you have some design duties. Who can amend this list? Who can change this list? At the moment, the Commission wrote that the Commission can improve the list, right? But this is something that is being discussed also. And then you have a part of limited risk, right? You have, for example, deep fake, deep video or images, very realistic ones, or emotion recognition systems, or any form of AI interacting with humans. And in this case, you have some transparency duties, right? Just that, transparency duties like disclosure. This is AI. I mean, emotion recognition is very, very problematic, right? And then for other AI systems, there is, of course, no problem, and they can adopt voluntary codes of conduct. That is also interesting because in this voluntary codes of conduct, you have something new. You have for example, among the best practices, you have participative design of AI. I'm very sorry it was just in the voluntary code of conduct and not in the high risk, for example, accountability duties. Participation in the AI design is something very, very challenging, useful to overcome many problems: underrepresentation of minorities, protection of vulnerable people, fallacy of consent, and the transparency, because end users don't understand very well. And if you include them in the design process, everything changes. Okay, next slide, please. Opportunities, because of course there are many opportunities in the AI Act. First of all, the legal recognition and definition of some concepts that we have been talking a lot, we've been discussing a lot: definition of AI, the mentioning of biases, or also, as I was saying, the red line for manipulative and social score manipulative practices, and so on. Then also the fact that you have practical solutions to mitigate human rights risks of AI in sensitive areas. And also the fact that you have some solutions by design, for example, human oversight and so on. This is something that, of course, might change the AI market as it is. I don't know if the predictions saying, oh, you know, this will block the innovation in Europe. I don't think so. I mean, GDPR didn't block, but was even a virtuous example around the world. But of course, there will be more discussion, and it's not yet approved. So many things will happen. The European Parliament had 1st of June as a deadline for the amendments of all proposed amendments by the member of the European Parliament, and they received something like 3,000 amendments or something like that. So imagine even just reading 3,000 amendments, right? It's challenging. So Next slides, we have the limits, I think, the challenges. I already mentioned many of them. So first of all, there is this problem on the limited scope on manipulation, because first of all, the effects that the European Commission proposes are just physical or psychological harms. Why not economic harms? I was asking this to Lucilla Scioli from DG Connect. She's like the head of AI in DG Connect. And she said, well, because economic harms are already protected by the Unfair Commercial Practices Directive. I don't know, are you familiar a bit with the Unfair Commercial Practices Directive? You think it's effective? I mean, in the AI age, it's not so effective, maybe, right? Because it was written in 2005. In 2005 was, you know, AI was not even a buzzword for scholars. So then also limited view on vulnerability. I did my PhD research on vulnerable data subjects. I don't want to open this Pandora box now, but just to say, the prohibited practices, the list of prohibited practices includes the prohibition of exploiting vulnerability based on age and disability. But there are many more vulnerabilities, right? Vulnerability is a contextual and relational concept, very difficult to include in a definition, but since very much relational. And why just age and disability? Again, the Commission said age and disability are easily provable. You can prove at your age through your ID card. You can prove your disability through a medical certificate. But the burden of proof maybe is not enough to limit the protection of vulnerable people. So the Slovenian presidency, the first semester after the proposal, so it was the end of 2021, proposed to add age, disability, and social and economic vulnerabilities, which is very interesting, very difficult to prove, in fact, but it opens many more situations, right? For example, recommender systems based on AI, of course, recommender systems nudging people in financial vulnerabilities, right? Or gamblers, people that are addicted to gambles, and so on. So this is something that can be overcome the problem that economic harms are not included in the other point. Limited risk, also why emotional recognition is in the limited risk, because they say, oh, emotional recognition is good for many things, we can't prohibit it. Okay, but at least let's put in the high risk list, right? Okay, then if we go to the next slide. I was writing this article before that the AI Act was was approved, was even proposed, sorry. And the idea was that actually we could regulate AI also through the GDPR. Of course, the definition of personal data is not, it doesn't include all AI systems, but it's very wide. And the point is that this discussion now is more interesting because the European Parliament co-rapporteurs proposed that the AI Act, proposed an amendment to providers of AI, so producers, sorry, of AI, to comply with Article 25 of the GDPR. So there is this proposal to put as a Trojan horse in the AI Act, privacy by design, sorry, data protection by design and by default. So you know data protection by design, right? More or less the concept, right? Implement data protection principles, Article 5. So basically, this is a way, if it's approved, it's going to be a revolution for legal scholars, for legal and tax scholars, because it will be the application of principles of GDPR, Article 5, to all AI Act. So to all AI systems, the high-risk ones. But still, this means that all people, I mean, we all criticize the AI Act because it's not principle based. It's very much based on a safety structure, like 70s. This idea that it's like you can't regulate a fridge as you regulate AI systems. So the approach should have been different. Yes, but the devil is in the details. And if you say that Article 25 of GDPR should apply to all AI system providers, it means that it's principle-based because you are using Article 5, so the principles of the GDPR, in the AI Act. And so in the next slides, we will see how we can skip this ones, I think, because I'm changing a bit the structure. Yeah, I mean, this, the risks, the biases, so we move. Okay, again, thank you. Yeah, so just a quick recap on how the GDPR already reacts to risks of automated decisions. There is the three things: transparency, a right not to be subject to automated decisions, and accountability duties. I assume you all know this. You're, I mean, excellent PhD students. We can skip this part, but just to give a view of all the steps that will bring me to the conclusion that just with the principles of Article 5, we can do a lot. So we can move. Yeah, I mean, yeah, we move also this one. The impact assessment is the first step that I think should be considered, because also the AI Act has a risk assessment there. So this is just an explanation of what is the impact assessment, nothing new at all. But if we consider that all automated decision-making systems are producing similarly legal or similarly significant effects, are under the umbrella of Article 22, are under the umbrella of high risk under Article 35, means that the data protection impact assessment needs to be done for all automated decision-making systems. And this means that the data protection impact assessment should be in strict link with the risk assessment in the AI Act. So how the two systems, okay, it's two different moments, because the data protection impact assessment is done by data controllers. The risk assessment in the AI Act will be done by the producer and eventually by the user. And the user is not the end user. The user is your university adopting an AI, your hospital adopting AI, or So the point is, controllers have more duties in the GDPR, and infrastructures are called processors, right? Data processors like cloud services, etc. In the GDPR, in the AI Act, it's the opposite. The infrastructures are called producers, and they have more duties. The user is what in the GDPR is the data controller. So basically, there is this cross, right? Where you have more, so a company using AI for workers, for performance evaluation of workers, will have many duties under the GDPR as a data controller, but will have fewer duties under the AI Act, because most of the duties were on the producer, on Microsoft, on, I don't know, Alphabet, or whoever is. So this is something we should, I mean, I'm just giving you, questions for the future. How do the DPIA and the risk assessment in the AI Act will interact? If there should be a dialogue, for example, if a hospital adopting an AI system should be able to read the risk assessment that the high risk producer is producing, sorry for this, and work on that for the data protection impact assessment. This might be something. If we can, yeah, and in my view, yeah, there was an animation that in the PDF was, but okay. So in my view, as I was saying many times, the data protection impact assessment and automated decision-making rules are already overlapping, because actually you have to describe the data processing under the data protection impact assessment, but you have to give meaningful information about the logic, the significance, and versus the effect of the algorithm under Article 13, 14, and 15 of GDPR. So again, we shouldn't consider atoms. We should consider all these procedures together, and even the AI duties, the AI Act duties and GDPR duties together. Okay, this was something I wanted to underline. And so in the GDPR, we have to consider individual rights and accountability duties together, because it makes sense, it's helpful for data controllers, and also it's in a way required. And also it will be nice to see this link between AI Act and GDPR duties. If we can move. Now the final part, I don't know how much I have. Okay. The final part is, justification and why justification? So why I'm introducing this word of justification more than rather than just explanation? Because this is another point that lots of legal scholars were addressing. Explanation has problems, right? The AI Act is proposing in Article 10, I guess, to address understandability even by design. And there were some changes that the French presidency proposed. The first version was interpretability, the second was in understandability. It's interesting to see this difference. I don't know what you think of this difference, but understand, in my view, I mean, as a lay person, I don't know about, I'm not a computer scientist, but I think that understand is more, for a non-technical audience, and interpret is for a technical audience. Maybe this might be a first difference. Or second difference, interpretability is by design, understandability, so ex ante, understandability is also ex post. But of course, these are words, and we know we can't comment on proposals of amendments and amendments because we would be lost in the loop, right? So there will be a lot of discussion in the next year or two, and I hope at the end of 2023 we will have an approved text or something more or less approved on which we will be able to give our final evaluations. I see there are already 3 papers commenting the proposals. There is Frederick Borghesius and Michael Wild paper on the AI Act from the European Commission. Yesterday was put on AI and Society, was published another comment, sorry, AI and Law from the European Council version. I mean, it's hard to work on proposals because, you get old very, very soon if your paper gets old very, very soon. So again, justification. So justification, I think it's the right word that we need. Why? Because first of all, we want explanations, but why we want explanation of black boxes? Why we want explanation of algorithms and automated decisions? We want explanations because it can enable our reaction. It can enable our right to contest. But if I want to contest, I don't think I want to contest the technical aspects of the algorithm, right? I don't think I want to say, oh, look, I think that the training model had this technical problem. I want to contest on some socio-economic, social structures, because there's social legal reasons, right? I want to contest because I feel discriminated, because I feel manipulated, because I feel stigmatized, because so what would be more useful for the data controller, for the data subject, is a justification. And what I mean by justification is to understand why that automated decision-making system or that AI system was not unlawful, was not unfair, was not discriminatory, and so on. So reading that justification, which also has a part of transparency, so also a part of explanation, I can have a broader picture of what's happening. I can have a broader picture of the decision that has been taken, and I can contest easily, right? And also because explanation might be hard. Justification is easier in terms of narrative. The narrative of justification is, a data subject friendly narrative in a way. Explanation might be also very, very complex. It depends, of course. We are talking about abstractions now. Next. You can click on all of them because they are, here I have just some, go on. Okay, I have some forms of justification that we can find. What is justification? Why I wanted to address this point on justification. In the comments, I mean, the first is from Oxford Dictionary and say justification is to prove or show to be just, right, desirable, or reasonable, right? Then in theology, it's right is in the sight of God. In science, is to be correct, verified through the scientific method. In explainable AI literature, I mean, this is what I think, I mean, in a paper by Lazzaro Lemaitre, no, sorry, Daniel Lemaitre, he was proposing this definition of justification as being good. The decision is not just, I mean, a decision is good. Explaining the goodness of that decision is a justification, okay? In philosophy, it's reach desirable goals, etc. You understand that the point here is not just explaining how the machine, let's call it machine, went from A to B. But justification is how the path from A to B is compliant with some external norm. External, that can be philosophy, theologies, and so on. And in our field is law. And what law? I mean, principles of GDPR, for example, right? So for me, justification is to show how the decision-making from input data to output data brought to something that is respectful of lawfulness, fairness, transparency, purpose limitation, data minimization, accuracy, this data storage limitation, integrity and confidentiality, and even accountability. And this is something that data controllers could do because they do a data protection impact assessment. So they are already assessing necessity and proportionality. They're already doing this exercise, and they might easily prove that the decision-making system is not in violation of all these principles. These are just the principles, okay? Yeah, this is something I already said, that now data protection by design, it's an amendment in the AI Act, so we will see if it becomes reality. And so just this proposal, just to be provocative, I think the idea is to have illegality by default of all high-risk AI system, and they have to prove ex ante that the algorithm is justified. So they have to explain how the AI system respects the core of data protection. This is not the law. This is a proposal that Frank Pasquale and I were suggesting in a paper. Is already on SSRN if you want. It's called Beyond Transparency, and the longer title that I don't remember. And so the idea is that the AI systems should be in a way justified before that they are approved, right? And not simply on the fact that, you know, they're already in the market, then we do some accountability duties and that's all. Because the ex-ante part of, you know, it might seem a bit prohibitionist, paternalist, yes. But, you know, in this phase, I mean, it's not, because you just approve and then they can be in the market. You just change it's also an enforcement problem, right? The EDPS, and I know Massimo is online, the EDPS organized a few weeks ago a whole 2 days conference on enforcement, and we saw that enforcement is a big problem. So why don't we move the enforcement to the approval movement, so ex ante? And we see this AI system is approved, this AI system is not approved. The GDPR had I mean, the father of GDPR was the Data Protection Directive, and the Data Protection Directive in many countries was already considered under a prior approval framework for sensitive data. For sensitive data, the data protection authorities had to, had to authorize the processing of that data. So it's not something totally far from visibility, okay?
Sorry, Gianclaudio, if I may.
Yeah.
Shortly, think, okay,
Yeah,
thank you. If you could come to the end, thank you.
This was the last slide because the other one were just redundant. So just this, and I'm very happy to hear any questions. I know it was every kind of questions. It's and also maybe discussion with DG Connect since we have some.
Thank you very